What's going on, y'all? So I had a court date today for January 13, 2026, and as you can see, it's against Queens Wellness Medical Care. It's a notice of motion to renew and re-argue, and I'm pretty sure y'all are very familiar with this case. I had uploaded the inquest hearing that was held before Melissa B. Berry, and this is about a little over a month ago, and I'm waiting for the decision, but the defendant decided to file a motion to renew and re-argue. Now, what I want to so when I appeared in court today, I seen that Amish R. Doshi was on the bench, the same judge that was on the bench from my court appearance yesterday. And so I thought it was going to be a bad look, but it didn't turn out so bad. So long story short, he decided to adjourn the case to the end of February, and he said because it has to go before Melissa B. Berry. Because when you file a motion to renew and re-argue a decision, you have to re-argue it in front of the judge that handed down the decision. And that makes perfect sense because they know all about the case. So he adjourned it to the end of February, y'all, and it just prolonged the case. And I think they're doing that on purpose because, like I said, she only has 30 days to make a decision. And it's just like, you just prolonging this. But what I want to point out to y'all as well is that when you're dealing with this law stuff, if you're not willing to research, look up everything, review everything, pull up all these laws, these statutes, forget about it, man. Because I didn't realize this. There's some new argument I got. I didn't realize until today. And it's this Cplr 2221D and subdivision E. Now, these two laws allows him to file this motion. So you definitely want to look that up. You want to review that. At first, I wasn't even looking that up. I had other arguments. But you want to look these up and see if they complying with the law, with the subdivision. See if they complying with it. So when you pull up 2221D subdivision 2, because you got to pull up D, you pull up D and read everything under D and everything under E. And the one in the subdivision under D, I want y'all to read is number 2. And it says a motion for leave to renew and re-argue shall be based upon matters of fact allegedly overlooked or misapprehended by the court in determining the prior motion. So there has to be a prior motion. Then when you look at E subdivision 2, it also speaks about a motion, a prior motion. So long story short, there has to be a prior motion made by the defendant that was denied in order to re-argue. There was never